We now turn to substantive constitutional law. Again, the organization of this subject matter is contained in this book on constitutional law, and on page 2 of this book is the diagram which you see on the board, and you may follow either from the board or the diagram. There is more detail on the diagram in the book. Now, substantive constitutional law is about the question, did the government violate the Constitution? There are two governments for our purposes, the state governments and the federal government. And the question is, did that government violate the Constitution? Now, there are only two ways that the government can violate the Constitution. They are, number one, the government might act in a way that it was never authorized to act, that it is doing things, trying to accomplish things which it was never authorized to accomplish. Secondly, the government, even though it is attempting to do something it was authorized to do, it is doing it in such a way that it has gone too far and has invaded or violated either the rights of an individual in trying to do something that it was authorized to do, or it has violated the rights of the other sovereignty. Remember, there are two sovereignties, the federal government and the various states, each state being a sovereignty of its own. Let me give you an example so that the concept is clear. Let's suppose that there is a Board of Education, a governmental entity, which is authorized to regulate, to pass rules on matters regarding the education in the school system. Let's suppose that this board passes laws regarding the speed of traffic on Interstate 5 in California, and the school is not even related to Interstate 5, not even close to the highway. So this school board is obviously acting in a manner that is beyond its authority. It has no authority to regulate the speed of traffic on Interstate 5. When a governmental body acts beyond its authority, of course, we give it no legal effect. The name for that is that the government has violated substantive due process. Substantive, not procedural, but substantive due process. It is the equivalent of the old Ultra-Vires Act in corporations law. When a corporation is authorized to engage in certain kinds of activities in its articles, and now the corporation acts in a way that is not even related to the kinds of things that it is authorized to do, we say that corporate act was ultra-vires. And if it cost the corporation money, then the people who did it, the directors who did it, are liable to damages to the corporation for doing that. Well, just as a corporation has been authorized to do certain things, the government, city, county, state, in particular state and federal governments, have certain authority, and they must act within that authority. Otherwise, what the government has done is acting outside of its authority, and that violates substantive due process. So the key problem then becomes, how do you determine what the government is authorized to do? What is the state government authorized to do, and what is the federal government authorized to do? And we will look at that in just a minute. But obviously we need that source of authority. But to get the big concept clear first, let's continue that if the government acts outside of this authority, whatever the authority is, that violates substantive due process, and it's void, and the statute or whatever it is has no effect. If it is, rather than a legislative act, if it is an act of a person which violates substantive due process, then the government may be liable for damages. Certainly you're entitled to some remedy if the government has injured you by acting outside of the authority given to it. Obviously, one of the things you might argue is that the person who acted beyond the authority of the government, beyond the authority that the government had, that person wasn't acting any longer on behalf of the government, that they're acting on their own and they're personally liable. So there are various claims that you might make when the government has acted beyond the authority given to it. And we have to find the authority. What authority does the state have? What authority does the federal government have? And we'll look at that in just a minute. But keeping the big picture clear, the other way, so one way that the government can violate the Constitution is to violate substantive due process. The other way that the government can violate the Constitution is, although it was acting within the authority given to it, it exercised its authority in such a way that it invaded some other limitations. It violated some other limitations on its conduct. Let's go back to that Board of Education for a moment. And the Board of Education can regulate school matters, and it passes a law regarding speeding on Interstate 5, and that obviously violates substantive due process, and the law would be given no effect. Let's suppose that the school board passed a law regarding schools, but the law which they passed violated equal protection. Well, that's the school board going too far. It's a law that regulates school matters, so they're within, it's rationally related to something that they're authorized to do, but they violated equal protection, or they invaded the student's right to privacy, or they invaded the student's right to free speech, or they violated privileges and immunities clause because they won't let people from out of state attend your schools. So the point being that even though the school is dealing with school matters, and even if the law would promote the welfare of the school to some extent, and it's rationally related to the welfare of the school, if the school board has gone too far so that they have invaded individual rights, free speech, right of privacy, equal protection, right to travel, privileges and immunities, and so forth, they've violated some individual right, then that school law is going to be invalid again. So we have two reasons that this law might be invalid. Violates substantive due process, or it invaded some individual right. Another way that the school board can go too far, in my hypothetical, is instead of violating some individual right, which is going too far, the school board might pass a law which violates the Supremacy Clause of the United States Constitution. So if this state or local school board passes a law which violates the Supremacy Clause, again, they've gone too far. They've invaded the sovereignty of the federal government, and that law would be invalid. So we see that then the big picture is that there are two and only two ways that a government can violate the Constitution. One is they can violate substantive due process by doing something they were never authorized to do, or going too far in that they've invaded the rights of the individual, or in the case of the state, they've invaded the rights of the federal government, actually the sovereignty of the federal government. Now, if it is the federal government who is acting, it's some federal agency, the Atomic Energy Commission, or the Interstate Trucking Commission, or some federal agency, how can the federal agency violate the Constitution? Answer, there are only two ways to violate the Constitution. One is they were never authorized to do it. Secondly, they went too far. Looking at some federal agency, if the federal agency acts within the authority given to that agency, then they're acting within the authority given to it. If they try to do things outside the authority given to that agency, it violates substantive due process. Well, let's switch from this agency to Congress. Well, Congress obviously has some authority that is given to Congress. The authority that Congress is given is in Article 1 of the Constitution. We'll look at Article 1, Section 8 in a few minutes, And that's a list of all the powers given to Congress. And the only powers Congress has are listed there in Article 1, Section 8, or in some of the amendments to the Constitution, where Congress is given a few additional powers in those amendments. So the only powers that Congress has are those powers which are listed in those places. If Congress tries to do something outside of those powers, it's acting beyond the authority given to it, and therefore violates substantive due process, and the law is void. The second way that a federal agency, whether it's Congress or some federal commission or something, the second way that they can violate the Constitution first is acting outside of the authority given to it. The second way is going too far. Well, how can a federal agency, Congress or some commission or some federal agency, how can they go too far? There are two ways that they can go too far. One is if the Congress or some federal commission invaded the individual rights of a person. The Congress or some commission violated equal protection, due process, right of privacy, privileges and immunities, any of those individual rights, that's going too far, and that would make the law invalid. And the second way that the federal agency can go too far, besides invading individual rights, is they can invade the sovereignty of the state too much. The 10th Amendment says that the states are still sovereignties, and if the federal government invades the sovereignty of the state too much, for example, suppose the federal government passes a law, says the states of the United States will pass a law that does the following things. Well, if the states have to pass a law, that invades the state's sovereignty. The states have a right to decide what laws they want to pass for themselves. Suppose the federal government passed a law that says all of the police departments of cities and counties and states throughout the United States will from now on enforce the following law. Well, if Japan can tell your local police department what to do, where is your sovereignty? And so obviously, if the United States federal agency or government or Congress or anyone tells your local police departments you will now enforce these federal laws, that's invading the sovereignty of your state too much. So the two ways that the federal government can violate the Constitution is to act beyond the authority given to it, and we still have to enumerate that authority, or they can invade the rights of the individual too much by violating individual rights, or they can invade the sovereignty of the state too much in violation of the 10th Amendment. Now, let's look at the diagram and see how the diagram on the board expresses these concepts. Here, under substantive con law, the question is, did the state violate the Constitution, and did the federal government violate the Constitution? To answer the question, did the state violate the Constitution, the first question, there's only two ways to violate the Constitution, this way and this way. Was the state authorized to do what it did, and did the state go too far? On the question of was the state authorized, what kinds of things is the state authorized to do? And the answer is the state is authorized to promote the health, welfare, safety, and morals of its citizens. These are the only things the state is authorized to do: promote health, welfare, safety, and morals of those people subject to its jurisdiction. Don't have to be citizens. Health, welfare, safety, and morals. This is the so-called police power of the state, meaning police power in the broad sense, not in the cop sense. So if the state has the police power, and here it is, and these are the only things that the state is authorized to do. This RR means that what the state does must be rationally related to one of these components of the police power. A rational way to promote health might be to pass a law raising taxes on cigarettes. A rational way to promote safety might be to post stop signs and speed limits. These are all rational ways to promote safety. Rational way to promote welfare and morals. Welfare is sort of, general stuff, and morals, say what you want to about that. So what the state is authorized to do is to promote these things, and anything which the state does, which is a rational way to advance health, welfare, safety, and morals, is within the authority of the state. A state law which advances the benefit of some individual does not meet these standards. A state law which is completely arbitrary does not meet these standards. Obviously, it is very difficult to find a state law that is not rationally related to one of these components of the police power. Particularly this broad one, welfare. Welfare is so broad that it's hard to find a state law where you can't make some kind of a rational argument that it promotes the welfare of people subject to the jurisdiction. So you seldom find a state law which is void because of violation of substantive due process. On the other hand, the state law can go too far. How can the state law go too far? There are two ways that the state law can go too far. One, it can go against the federal government too far. It can go against individual rights too far. Let's look at the federal government. If the state law goes against the federal government, there are two ways that the state law might interfere with the federal sovereignty. Two ways that the state law might interfere with federal sovereignty. One is that the state law might violate the Supremacy Clause. Two, the state law might violate the Commerce Clause, because according to the Constitution, the federal government has the right to regulate interstate commerce. They can regulate it as much as they want to. And when the state starts regulating interstate commerce, that might violate the Commerce Clause, the so-called dormant Commerce Clause. And we'll look at more detail about that in a few minutes. But these are the two structural ways that the state laws might invade the sovereignty of the federal government too much. Supremacy, Commerce Clause. Now let us look at did the state law go too far? That is, even if the state law did not violate the Supremacy Clause and did not violate the Commerce Clause, the state law might still invade individual rights. And so here, if the state law goes too far against individual, invading their individual rights, that would make the state law unconstitutional. In the diagram in your book, there are 13 or 14 of these individual rights. I've obviously abbreviated them here on the board, but they're rights. They are individual rights, such as equal protection, due process, freedom of speech, right of privacy, privileges and immunities, contract clause, right to travel, all that sort of stuff. 13 or 14 of these. For bar purposes, what you are required to know is exactly how do you define the boundary? When has the government gone too far and violated each of these rights? Take the right of due process. The government, exactly when has the government taken away life, liberty, or property without due process? Take speech. When has the government invaded free speech too much? Obviously, the government can regulate speech to some extent. For example, we can have things which are top secret, and you cannot, even if you're working for the government, and you know the top secret, you cannot disclose it. You can't yell fire in a crowded theater, that sort of thing. So there are limitations on free speech. but exactly when has the government conduct crossed the line? And knowing where that line is a critical part of what you need to know in preparation for the California bar exam. For each of these 13 or 14 individual rights, you need to know how exactly when, what kind of conduct crosses the line. You need to know the words of the rule. You need to know how to interpret that. What do those words mean? So you can look at the conduct of the government and decide, has the government gone too far? This is a major part of what you are required to know for constitutional law. For each of these 13 or 14 individual rights, you can count them there in that mnemonic on the evict bad Peters in mnemonic. I keep forgetting whether it's 13 or 14. Whichever it is, for each of those, you need to know the words of the rule, and you need to know enough about the case law so that you can look at facts and decide whether or not on these facts has the rule been violated. So for each of these in your study of con law, learn a way to state the rule and learn a case or two about that rule so you can help decide when the rule has been violated. You don't need to know a whole battery of cases, just a couple will do. But learn it and you will do a whole lot better than if you just kind of tried to make up something about these. So here, has the state gone too far? The state can go too far by violating the sovereignty of the federal government or by violating individual rights. Now let's look at the federal government and decide the question, when has the federal government violated the Constitution? Well, pardon me, did the federal government violate the Constitution? Same two things. There are only two ways to violate the Constitution. The federal government was the federal government authorized to do what it did? Did the federal government go too far? What is the authority of the federal government? Well, the authority of the federal government is found in the U.S. Constitution. Article 1 gives you the limitations on the legislative branch. Article 1 tells you the kinds of things that the legislative branch can do. So this is legislative. I'll put a big L, L-E-G for legislative. And in particular, the list of authorities of the federal government in Article 1 are found in Article 1, Section 8. And I urge you to please read Article 1, Section 8. Please read it. Please don't just plan to read it. Actually read it. If you're going to take a course in Constitution, take an exam in constitutional law, and you don't even bother to read in the Constitution itself, not what other people said about it, but in the Constitution itself, what authority Congress has. If you don't read that, you're crazy. So please sure to do that. Secondly, Article 1, Section 8, big deal. Please notice at the end of Article 1, Section 8, where it lists the various kinds of things that Congress can do, Article 1, Section 8, at the end, it has the necessary and proper clause. The necessary and proper clause. Let me read you the necessary and proper clause so you can see what it says. At Article 1, Section 8, it says, they've listed all the stuff that Congress can do. Then it says, the last of Section 8 says, to make all laws which shall be necessary and proper for carrying into execution the foregoing powers. Okay, and there's a few more things there. So the necessary and proper clause does not give the Congress additional powers. It simply says, here in Article 1, Section 8 is the stuff you can do, and you can do anything that's necessary and proper to achieve that. In other words, it's saying what Congress does needs to be rationally related. Whatever you do in Congress needs to be rationally related to one of these powers, one of these enumerated powers. So the necessary and proper clause doesn't add any new powers. It simply says what you do needs to be rationally related to the powers which are listed. Article 2 is the executive branch of the government. It says, here are the things the executive branch can do. Please read it. Article 3, the judicial branch. List the things that the judicial branch can do. Please read it. So this is where Congress gets its initial powers. Congress here, executive here, judicial here. Then there's some amendments to the Constitution. There are some amendments to the Constitution, and sometimes these amendments to the Constitution give Congress additional powers it did not have without that amendment. Let me show you one or two of those. If you look in this book and you look at the Constitution itself, let's look at some of the amendments and you'll see what I'm talking about. I begin with the 13th Amendment. 13th Amendment, Section 2 of the 13th Amendment says, Congress shall have power to enforce this article by appropriate legislation. 13th Amendment, you can pass laws to enforce the 13th Amendment. Well, that's additional powers that Congress had that wasn't listed in Article 1, Section 8. Take a look at the 14th Amendment, Section 5 of the 14th Amendment. Section 5 of the 14th Amendment says, Congress shall have the power to enforce by appropriate legislation the provisions of this article. So the 14th Amendment, Section 5, gives Congress some additional powers. Look at the 15th Amendment. 15th Amendment, Section 2. The Congress shall have power to enforce this article by appropriate legislation, and so forth. And there are some others. In the 19th Amendment, Congress shall have power to enforce this article by appropriate legislation. So the point being that in the amendments to the Constitution, here, in these amendments, there are some additional powers that Congress has. So Congress gets its power from Article 1 and the amendments. The executive branch from Article 2, judicial from Article 3. So the first, going back to here, did the federal government violate the Constitution? Was it authorized? Did the federal government go too far? And the way the federal government can go too far is to invade the individual rights. It can invade the state. It can go too far against the state, pardon me. And if they go too far against the state, right here, this is in violation of the 10th Amendment. I'll draw this line right here for the state, 10th Amendment. So Congress can pass a law which invades the sovereignty of the states too much. An example of that, again, is where Congress passes a law telling the state what laws it's going to enforce. And that's invading the sovereignty of the state. That would violate the 10th Amendment. And finally, Congress can go too far by invading individual rights, and it's the same set of individual rights which are protected under the Constitution, whether it is the federal or the state government that goes too far and invades those rights. And again, this is a critical part of your preparation for a con law question. And for each of these 13 or 14 individual rights, you need to know a couple of key cases, one or two cases. In the speech area, you might know some extra cases, because this is the biggest of all the areas in the speech area. But in the other areas, a case or two that tells you something about them that you can use, a key case, one or two of them, and use it in your answer. You'll do a whole lot better if you do that than if you just kind of talk in generalities. So what we know then is that we know how to decide whether or not a government agency has violated the Constitution. Only two ways to do it. If it's a state, there are two ways. Same two ways if it's the federal government. The only difference between the federal and the state government is that in the case of the state government, it can go too far by invading the sovereignty of the federal government. In the case of the federal government, it can go too far by invading the sovereignty of the state. But in the case of each of them, they can go too far by invading individual rights. So that's the broad picture, and it's very important that you keep that in mind. And let's look at the next level of detail. Let's start here where we say that if the state was authorized because it was promoting health, welfare, safety, morals, did the state go too far against the federal government? Well, how can the state go too far invading the sovereignty of the federal government? Supremacy Clause and Commerce Clause. As to the Supremacy Clause, let's take that one first. The Supremacy Clause, we know what it says, that the federal government laws are supreme, and if there is a conflict between the federal and the state law, that the federal law prevails. There is a conflict if if the federal law function is interfered with by the state law. If the state law makes it more difficult to perform the federal function. The preemption doctrine is a component or an aspect of the Supremacy Clause. What the preemption doctrine is about is saying that there are some cases where you do not have a direct conflict with a federal law. In other words, if the federal law says do X and the state law says don't do X, that's a simple problem. We know what to do about that. But if the federal law does not address the question at all, and now there is a state law which addresses that question, can the state law be invalid in violation of the Supremacy Clause even though there is no federal law on point at all? Can that happen? Answer is yes. For example, suppose there is no state law which regulates the gauge of railroad tracks. And by gauge, I mean the spacing, the distance between the two tracks, and how the size of the tracks so that trains can run on them. And let's suppose that there is no federal regulation of this, and suppose the state of Texas says, in our state, the railroad tracks will not be separated by however many feet it is. They'll be separated by some different distance. It's a funny thing, the railroad tracks, the gauge of railroad tracks was historically actually because of the wagon tracks, the spacing between the wheels on wagons, and so, you know, it's kind of arbitrary, but in any event, started out that way. And suppose Texas says, in this state, the spacing of between the railroad tracks will be something different. Well, that would mean that the trains couldn't run through Texas without people getting off and getting on a different train that had different kind of tracks that would fit the different tracks. That obviously would be a major disruption of interstate commerce. It happens in Europe, as you well know. You can't go from France to Spain without changing trains because they did exactly what I described. Now, but if there is no federal law, the state law can still be declared invalid as under the preemption doctrine. Even if there is no federal law at all, if the state law would interfere with the intent, with the national uniformity, if there's a need for national uniformity, and there is no federal law at all, and the state law disrupts that need for national uniformity, then the state law can be declared void as a violation of the preemption doctrine, and so the even though the federal government has not really regulated the area. The way that works is that if the federal government let's talk about preemption itself for a moment. If we come down to the state level and a state law preempts a particular area, take the homicide. State law says, here's what you do in the case of homicides. Suppose a city ordinance was passed, and the city ordinance says, in addition to everything that the state does to people who commit homicides, we, the city, also will charge them $100 for every homicide they commit. Okay. Well, it doesn't contradict the state law, but is that city law valid or not? And the answer is it's invalid, and the reason it's invalid is because we say that the area of homicide has been preempted. That whole area has been preempted by the federal government, by the state law, by the state government. So any laws which the cities pass about homicides are invalid because the state has occupied that whole field. You can't add to it, contradict it, subtract from it. It's preempted. Now, if you extrapolate that from cities and states to the federal government, if Congress has preempted an area, then any state law in that area is void, even if the state law says exactly what the federal law says. A city ordinance that copied the state law on homicide would be void. So a state law which says exactly the same thing that the federal law says, or adds to it, or does anything of that sort, if the Congress has preempted the area, all those state laws are void under the preemption doctrine. How do you decide whether or not Congress has preempted an area? Well, Congress can say, we hereby preempt the area of atomic energy power, or the atomic power. Congress could declare that they preempt an area, but they seldom do. And the bar examiners aren't going to give you that one. That's too easy. But what you must do is to try to determine the intent of Congress. To decide if an area has been preempted, you look for the intent to preempt. Did Congress intend to preempt the area? Even though Congress has said nothing in that area, they may still have intended to preempt it. Railroad tracks is my example. Suppose Texas decided that everybody else in the country's got 60-cycle electrical current. We want 50-cycle electrical current in Texas. Well, you couldn't transfer power from Texas to the other states or vice versa because they're incompatible. And so that Congress, even if Congress had not passed a law, if there is a sufficient need for national uniformity, then Congress impliedly preempted the area just because of the need for national uniformity. Now, if Congress has passed, whether they passed a law or not, looking for intent of Congress, what factors do you look to try to decide what the intent of Congress was? Well, one factor you look to is the history. Who has historically regulated this area? The states or the federal government? If the states have historically regulated the area and then the feds want to regulate it, they probably did not intend to take over the entire area, but just to add something to it. But that's a factor, it's not a requirement, it's just a factor. So you look at the history of who has regulated the area to help decide whether Congress intended to regulate it exclusively. Another factor you look at is the need for national uniformity. In certain areas, there is a need for national uniformity. Railroad tracks, frequency of electricity, signs on the highway, that sort of thing. Need for national uniformity. Another factor that you look to in looking for the intent of Congress is, did the federal government create a commission or a federal agency to regulate this area? Now, often when Congress creates a commission to do that, they often intend to regulate the area by themselves. Not conclusive. There is an Atomic Energy Commission, for example, but states still have some power in that area. There is a Federal Aviation Commission, but states still have some power in that area, and so forth. And so the commissions do not necessarily, the existence of a federal commission or agency does not conclusively determine that the federal government intended to preempt the area, but it's a factor. So these are factors that you use to try to determine the intent of Congress under the preemption doctrine. If the area has been preempted by the federal government, then all the state laws are void under the Supremacy Clause. Next comes the Commerce Clause, and we want to look at if the states pass a law which interferes with commerce too much, will that state law be invalid? The answer, of course, is yes. The state law will be invalid if it interferes with interstate commerce too much. And the problem is going to be, how do you decide what's too much? When has Congress interfered with, when has a state law interfered with interstate commerce too much? This is a good time for us to take a break, and we will pick up after the break and continue with Commerce Clause.